All right. Good afternoon, everyone. I'd like to call a meeting to order and acknowledge that we're in Treaty 1 territory, the home and traditional lands of the Anishinaabe, Ojibwe, Innu Cree, and Dakota peoples, and the national homeland of the Red River Métis. Our drinking water comes from Shoal Lake 40 First Nation in Treaty 3 territory. My name is Neil Harden. I'm chairing today's panel. With me are Mike Colatruglio and Valerie Warhan. The secretary today is Crystal Harland, and the assessor is Svetlana Scheibel. We will be hearing applications for revision of the business assessment rule in accordance with the Municipal Assessment Act and the City of Winnipeg Charter. The matters for which revision is requested have been described in each application. We'll limit discussion to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matters must be sworn in. Be advised that comparisons of assessments of properties are not considered evidence of market value by the board. The board is appointed annually by council and is independent of it in the city administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order to be mailed to all parties as soon as possible. Please note that the board's decisions with respect to an application may be appealed to the Manitoba Municipal Board if the matter pertains to assessed value or to the Court of King's Bench if the matter pertains to the application of exemptions from taxation. Should you wish to appeal, information on how to do so will be included with the board's order. With respect to the hearing process, I will confirm the points of appeal with your property to be addressed with each applicant following the swearing in. We will then have the assessor's testimony followed by questions the applicant may have, and then the applicant's testimony followed by questions. Each side will have an opportunity to summarize if they wish. Once all the evidence about an application is being brought forward, the applicant may leave. The process will repeat for each item on the docket today. The session will close after all the applications have been heard, and the board will deliberate in private and make its decisions. You will receive the board's decision by registered mail as soon as possible. As information, all public hearings are live stream recorded and will be part of the public record. We'll be hearing items 1 and 2 on our docket today. Mrs. Harlan, please affirm the assessor's and applicant's testimony.
Yes, Mr. Chair. Madam Assessor, would you please state your full name?
Svetlana Scheibel.
Thank you. Do you affirm that the evidence you are about to give at this hearing is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Mercury, would you please state your full name?
James Mercury.
Thank you. Do you affirm that the evidence you are about to give at this hearing is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Cadieux, would you please state your full name?
Paul Cadieux.
Thank you. Do you affirm that the evidence you are about to give at this hearing is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Chair, I just got an email from Mr. Neufeld asking for a link. So I'll send him the link, and then would you like me to let him in?
Yes. And then we can swear him in now as well.
All right, just a moment, please. I've just admitted Mr. Neufeld, Mr. Chair.
Okay. Ah, there he is.
Yep.
Okay, can you swear Mr. Neufeld in, please?
Yes, I can. Mr. Neufeld, would you please state your full name?
Rocky Neufeld.
Thank you. Do you affirm that the evidence you are about to give at this hearing is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
All right, so the first item on today's agenda is the business assessment on 790 Sherbrooke for the 2024 assessment year. So Ms. Scheibel, I understand there's 3 points of appeal, so can you read in the base data and then we will proceed to hear the evidence on the liability.
Okay. Roll years 2024, business roll number 58129, business name Imperial Parking in owner Imperial Parking Limited. We have quantum qualification e-liability under appeal.
Okay. So liability has been appealed. So Mr. Mercury on liability.
Yes, thank you. So you have the brief that we provided, and I'll walk you through portions of that. And with me today is Mr. Paul Cadieux, who is a representative of the owner. He's the CFO of HSCF Property Inc., which is the registered owner of the property. And so just by way of introduction, the issue here today is whether the business assessment, the primary issue is whether the business assessment was properly issued in the name of Imperial Parking, sometimes known as Impark, which is essentially the manager of the Parkade facility. So this isn't a business assessment of the Parkade facility or most of the Parkade facility, I should say, 559 stalls of the Parkade facility at 790 Sherbrooke. That property is owned by HSCF Property Inc. It was acquired a few years ago from an entity that was controlled by what was commonly known as the Manitoba Clinic, which expect most board members, if not all board members, are familiar with. The clinic, Manitoba Clinic Holding Company, went through became insolvent and went through a receivership process, and the property was acquired ultimately by HSCF Property Inc. Mr. Cadieux can speak to that background, but I just wanted to introduce the issue for the board before I go through it in the brief. So just by way of background again, and value has also been appealed, but it's a secondary issue. And frankly, if the liability issue is determined as we are suggesting it should be, the valuation issue becomes a moot. So we'll deal with liability first, of course. If you look at, if you have access to my brief, and if you just by way of background at page, I'm looking at the PDF document. This is tab 2 is the status of title document. So you can see the property is owned by HSCF Property Inc. Tab 3, and I'll explain this document, is that after HSCF, I'll just for short, acquired the property, it received certain notices for collection of unpaid business tax that the city had been issuing to the prior owner, Manitoba Clinic Holding Co. Ltd., which was the company that became insolvent, and ultimately property was sold. This notice that you see, July 30th, 2024, it was directed to our office to attempt to address. So the city was, you can see, was attempting to collect unpaid business tax. and without going through the entire detail of all of this, what appears to have happened is that business assessments and business taxes bills had been sent to the Manitoba Clinic Holding Co. Ltd. previously, and those bills were not paid in a timely manner. A number of other bills weren't paid as well, but amongst them were the business tax bills. For whatever reason, the city changed the taxable party to HSCF Property Inc. At some point in time, or changed the demands for unpaid business taxes to HSCF Property Inc. That led to a long series of emails and exchanges between my office and the city indicating that a subsequent owner is not responsible for an previous owner's business tax bill. They ultimately agreed with that. So these demands for unpaid business taxes were dropped. And so I'm going to skip ahead now to tab 4. And what you can see here is at tab 4 is this is the previous business assessment for the Parkade facility. You can see the notice was issued in 2022, the top. This is the 2023 business assessment. And the name of the
I'm
assessment.
having that under tab 4. My tab 4 is entirely blank.
Is it just say tab 4?
Yes.
Okay,
Says
and
tab
then
4, then several blank pages after that.
oh, really? Is that everybody's?
I have them.
I do
Okay.
too.
Let me go back to the original.
It's there.
Wonder why I'm not getting them.
I
didn't.
I would
Let me-
happily share my screen if I was able to do that.
No, I just reopened it on the SharePoint thing. Let me see if it's there.
Okay.
I had downloaded it, and for some reason, those pages didn't show up. Oh, yeah, they're showing up now on the SharePoint. So, okay, go ahead.
Okay, you have it. Okay. So this just illustrates to you, this was the genesis of it. The 2022 notice, the assessment notice, went to the Manitoba Clinic Holding Co. Ltd. So they were the previous owner of the property. There's an office tower as well as a parkade. They owned it all. This assessment notice for $613,440 was in respect of the parkade facility. And you can see it was issued in the name of Manitoba Clinic Holding Co. Ltd. At that time, and continuing today, the parkade facility was managed by Impark. They've been there for some time, and they've continued to provide parking management services for the owner of the building, which is now HSCF Property Inc. But nonetheless, back in 2022, the city had issued correctly, in my view, the assessment notice to the Manitoba Clinic Holding Co. And you can see again at page 25, this is the assessment notice in 2023. Once again, they've issued the notice to Manitoba Clinic Holding Co. Ltd. for the parkade. And there you see the assessment notice. Then there appeared to be some administrative confusion at the city's end perhaps with the sale of the building. There were new tenants that had come in. You can see at page 26, now you have the assessment notice for the parkade being issued to Well Health Technologies. Now, Well Health is a for-profit medical facility that rents space in the building, but they are not the owner of the parkade. They do lease certain parking stalls. They have parking stalls assigned to them. They're not the owner of the parkade. So that was issued in 2024. The city ultimately did correct it. They issued a business tax bill, which was eventually canceled. And now you turn to page 28. And the city, again, it's the same premises, the parkade, 559 stalls within the parkade. You have the assessment notice from 2024. Now the assessor is issuing the assessment notice back to HSCF Property Inc., which is the registered owner of the building and the owner of the parkade facility. This, in my view, was the correct property party to assess HSCF Property Inc. However, as we move ahead into tab 5, so that assessment was appealed by our office. I should say the 2025 assessment was appealed by our office. You can see that at page 30. Okay, so we were scheduled to go for hearing, and before we got to the hearing, the assessor decided to change the assessment again, page 34, and you will see at page 34, the new assessable party is Imperial Parking Limited. So they've issued supplemental assessments for 2024 and 2025, canceling the previous assessments to HSCF Property Inc. So nullified the previous appeal and have now issued the assessment notices to Imperial Parking Limited. Prior to these assessment notices being issued, we had notified the city indicating that Impark is simply managing the parkade. They're not the owner of the business. They shouldn't be, these assessment notices should not be issued to Impark. They should be issued to the owner. Nonetheless, notwithstanding our advice, these assessments were issued. Therefore, in light of the new assessments, which you've seen and are now the subject of this appeal, we obtained authorization from Imperial Parking Limited, and you can see that at page 37, to appeal the new assessments, the supplemental assessments in the now in the name of Imperial Park. So the issues, we're still challenging the value, but the issue is you have it assessed in the wrong name. It should not be Imperial Parking's assessment. It should be HSCF Property Inc.'s assessment, and I'll get into that briefly. So just see here. So yes, as I said, that's what leads us today. The email correspondence dealing with this issue is found at page 47 and on. And I'll just take you to the precise, if you look at page 50, as we were trying to deal with the situation, this is my email to representative of the City Taxation Department. I had indicated that the assessments should be issued in the name of HSCF Property Inc. rather than Imperial Parking. Imperial Parking is simply operating the parkade under a management agreement. HSCF is the owner of the real estate and the parking business. And I also noted in years past, the business assessments of the parkade appear to have been issued into the former owner of the property and not Imperial Parking. Their response to that was, we are simply going to issue it in the name of the parkade. So here we are. This is ultimately, I will have some comments for you on the legal reasons why it should be the owner, not the manager of the parkade. But what I was hoping to do was to have Mr. Cadieux, who is here, who can speak directly to the issues, the arrangement with Impark, so you can understand more fully how the parkade is operated, how its parking stalls are allocated, etc. And then I'll take you, once that's completed, I can take you to the case law that I actually have in my brief dealing with business assessments of parkades. I can deal with that now, like in terms of the legal argument, but it might be helpful for the board to first hear from Mr. Cadieux regarding the actual parking arrangement before I dive into that. Would it be permissible for Mr. Cadieux to speak to that at this point? We have a memo from him, which is at page 57 and 58, which outlines this, but I'd like him to briefly summarize that for the board, if that's okay.
Okay, that's fine. It's your case to present.
Okay. Mr. Cadieux, first of all, perhaps you could introduce yourself to the board members, and we can then go to your memo.
Okay, thanks, James. And hello to the board members. So my name is Paul Kedger, and I'm the CFO of HSCF Property Inc., and I'm also a director on the board of the entity. By way of background, I'll kind of walk through my memo that I wrote, drafted on May the 27th of this year. Just by way of background, we acquired the property, 790 Sherbrooke, which included the 10-story tower along with the adjacent parkade on December the 13th, 2023. And as James mentioned, that we acquired it from an entity called Manitoba Clinic Holding Co. Limited that was in bankruptcy protection. So that arrangement closed on December the 13th. Prior to that, it was operated by Manitoba Clinic Holding Co. Limited. But the parkade was managed by Imperial Parking Canada Corporation, so Impark. And their agreement was with the agreement they had together was dated July the 1st, 2019, and the term extended to June the 30th of 2024. However, as part of the purchase, we did not assume that agreement as part of the purchase of the assets. And so as a result, we had essentially a verbal agreement with Impark to provide parking management services. And the arrangement was 1.65% of gross revenues per month. So that's the arrangement. Now, I think what's important to discuss are roles and the respective roles, and I've outlined them in the memo. So Impark's role is just managing the parkade, and I'll talk about key decisions are made by HSCF Property, but these are just fundamental. They're important roles that they do, but they're not like senior management decision-making roles. So they've got some facilities, some back office capabilities. So billing and collecting monthly parkers, whether they're monthly or daily parkers, compliance, whether people should be parking or not, or haven't paid or have paid, small repairs to signs that are broken, some customer services. People will complain about something in the parkade. And then clearly they got to report back some financial results to us on a monthly basis, which we have access to all the books and records. So it's an important role, but certainly not a material role. The HSCF Properties role is really, we have full control over all material business decisions, including strategy, optimizing parking performance, parkade rates, daily, monthly, allocation of stalls to monthly parkers, approval of all communication to monthly parkers, decisions on delinquent payments, when to be more aggressive or not as aggressive, and decisions on towing. So that, some pretty fundamental key managerial functions. We approve any large expenditures, snow removal, contract cleaning, striping of the lanes and the lines. Those actually are engaged by our property manager, Cushman or CW Stevenson. And so those arrangements actually are funneled through CW Stevens, and they pay on our behalf. And then kind of the last couple of big ones are we approve all material operating costs, and the key one, approve all major structural repairs and maintenance costs. So what the memo is trying to do is essentially say HSCF Property is in full control of the parkade. We make all material key business decisions on this parkade. And arguably, I would say it's no different than the arrangement we have with CW Stevenson on managing the property itself. So they are just an arm, an extension of HSCF Property, because they have some of the capabilities that arguably we like to outsource to them. So I'm open and happy, that's my summary, and happy to answer any questions you may have.
Okay. Okay. And just for clarification, there's never been a lease in place with Impark. It's just strictly a management arrangement?
Yes, it is. There's no lease with Impark at all.
All right. Okay, well, thank you, Mr. Kadu. Thank you for the presentation. And there may be some questions from the board at the end, but I'm going to maybe pick it up from here and just continue to conclude the brief if I could. So you could just stand by for now. So if I could take the board back now that we've heard from Mr. Kadu and the memo, I'm going to take you to the actually, if we go to the very end of tab 14, I've included the relevant sections of the City of Winnipeg Charter. And this, of course, these provisions would be very well known to the board. If you look at page 83, 316 sub 2, premises used or occupied by a person for carrying on a business in the city, whether or not the person resides in the city, must be assessed for business assessment at a sum equal to the annual rental value of the premises. And that really, the question here is, there's no dispute that there can be certainly a business assessment for this parking facility, but whose business is it? There can only be one business assessment, and it should be to the appropriate party. And clearly, based on these facts, the quote unquote business operation is that of HSCF Property Inc., not of Impark, who's simply managing the property. Fortunately, this issue has been addressed in prior cases. Some go back a number of years in this province and elsewhere. I'd like to take you to tab 11. This is a case, interestingly, dealing with the Children's Hospital parkade back in the early 1960s. And very similar facts, actually. So if you look at page 60, back then the Children's Hospital had contracted out its parking management services to a third party called Corps of Commissioners to supervise it for hourly wages. To manage the parkade. I'm not going to take you through the entire case. But if you look at looking at the PDF, page 61, they actually had an agreement in place, very similar to what Mr. Kadu described with Impark. And there, the hospital had hired the parking operator, the management company, on a month-to-month basis. They were to manage the parking area to the satisfaction of the hospital on several following terms. Rates for parking shall be fixed by the hospital, just as rates are fixed here by HSCF Property Inc. They set out the rates. The hospital paid, was described as a salary for the management of the parking area equal to 30% of the net revenues after all operating expenses are deducted, and so forth. The question became whether that third-party entity should be assessed for business tax purposes, or if it was really the hospital's business, so to speak, in which case the business assessment should be declared invalid. And if you look at page 63 of the decision, second paragraph, that the issue posed by the court, the correct classification of the company in relation to the parking lot depends upon the agreement. I hold it by its terms. The proprietor of the parking lot is the hospital, and the company is an employee or servant. And going down, this last paragraph of page 63, it's my finding that the company cannot be assessed and taxed under the classification given in the notice of assessment. Going down further, next page, second paragraph, in my opinion, the intention of the legislature as shown by the taxing section is to tax the owner or proprietor of a business as contrasted with the person who has merely been put in charge of it. And they reference the section of the legislation, which is very similar to what we still see today in the City of Winnipeg Charter. And as a further ground for setting it aside, they said in that particular case, because the business tax was an expense, of the parking operator that was ultimately passed on to the hospital, it was essentially an indirect tax against the hospital. Now, we're not dealing with a hospital here, but the same principles apply. This is a management arrangement, not a lease. It's not Impark's business. They may structure their business elsewhere in different parking lots. I don't know, and that's really not before you. But certainly today, this is in essence the same as we saw in 1963 case involving the Children's Hospital. Another case at tab 12 is called Ritz Foods. I'm not going to go through it in detail, but essentially this involved a cafeteria operator within the several buildings, the Legislative Building, the Norquay Building, Woodsworth Building, and the Archives Building. And Ritz Foods was contracted to supply the cafeteria and dining room services at these 4 locations. The city decided to issue business assessments to Ritz Foods. And the issue became whether those business assessments were valid. It ultimately found its way all the way up to the Court of Appeal. The Court of Appeal said that those business assessments were invalid. This was not, the cafeteria was not Ritz's business. It was the business of essentially the government of Manitoba. And again, you can see at page 67, the references to the City of Winnipeg Charter. And at paragraph 7, court notes, literally interpreted, the act would make all businesses liable for the annual rental value of each and every building used by the business. This would mean that a painter who contracts his work for the painting of business premises would be liable for the rental value of every building he painted. That would be absurd. Although the business tax has been described as a personal one, we think there's no doubt it is tax levied with respect to real property. And at paragraph 9, the scheme of the act contemplates there will be an assessment with respect to each property equal to the ARV of the property. It's not within the contemplation of the scheme that more than one rental value be assessed. And if a business occupies the whole of a building, it will be assessed for the whole of the rental value. And if it contracts out a part of its undertaking to the contractor will not be liable for an additional assessment since the whole of the rental value has already been assessed. And so they, in deciding the case, that again, like the previous case I mentioned, they went through the agreement with Ritz Foods, and they noted the level of control that the government of Manitoba had over the cafeteria operator, and it referenced the fact that they had oversight over the overall operations, the hours of operations, how they were to be managed, the facilities, what could and could not be done within the cafeteria in terms of advertising, alcohol sales, prohibition, for example, and that all financial records of the operator to be made available for inspection to the government, just as here where Impark is required to turn over its financial records to HSCF Property Inc. for inspection to determine its fee. So again, the government, that business assessment was set aside. And then the final case I have is another parking case. This is one's from Ontario, Delta Parking Systems in the Township of Toronto. Without going through all of the detail, in that instance, there was a company who'd contracted with the government to provide management services for a parking structure at an airport owned by the Crown. And the issue was whether that parking operator was subject to business assessment. And for essentially all of the same reasons as set out above, the court held that the business assessment was improper. It was not the parking operator's quote unquote business. It was that of the government. And if you look at page 74, last paragraph, court indicates it seemed clear the parking structure was under the full control of the Crown, and that the occupation thereof by the applicant for the performance of the service was on behalf of the Crown and was the occupation of the Crown for the purpose of or in connection with the business of the Crown in providing parking conveniences for its customers, the users of the airport, and it might be added for the purposes of profit to the Crown. The applicant is not a tenant of land owned by the Crown for valuable consideration paid. There's no landlord and tenant relationship, and therefore the applicant is not in occupation or possession of the premises within the meaning of the Assessment Act. And in my opinion, it's clear the applicant is not liable to be assessed for property tax. So again, the authority on this is, I would suggest, overwhelming in terms of whether essentially a management company providing services in a parkade, such as here, is to receive their own business assessment. And the answer is clear. We thought this was resolved some time ago. I should add, not a reported case, but many years ago, I did bring a similar case to the Board of Revision. It involved the operator of the cafeteria at the St. Boniface Hospital, a company called Compass Group, who had a license to provide food services within the hospital. They received a business assessment that was appealed, and the Board of Revision set it aside, saying that it was essentially the hospital's food services business, not the Compass Group. And therefore there was no valid business assessment. So that, in a nutshell, is our position, Mr. Chairman, on the question of liability to taxation. So for clarity, it is not our position that there should be no business assessment at all for this premises, certainly not at this time. It's our position that the city actually had it correct previously when they issued the assessment notices in the name of HSCF Property Inc. And the correct way of proceeding here, it would be to declare this assessment as this applicant as not liable for business tax. And the city, if it deemed it appropriate to do so, could issue supplemental assessments in the name of HSCF Property Inc. It would be an unfortunate administrative process that would have to go through this again, but we have to get it right. And as it is currently before you, it's not right, and it needs to be corrected. So that's our position on liability. We have appealed value, and that's why Mr. Neufeld is here. We can deal with that separately. I'm assuming we want to go through the liability issue first, but obviously, if liability is determined in the applicant's favor, the value issue becomes moot. So with that, we're subject to questions.
Okay, questions, Ms. Scheibel?
Yes, please. We open tab 14 of agent brief. We're looking for City of Winnipeg Charter Act. First, we will look together on business assessment.
I'm sorry, which page are you on?
It's your tab 11, the City
Yes.
of Winnipeg Charter Act, Part 8. We're looking for definition.
Okay, I'm sorry, you're looking at, can you give me the PDF page number that you're looking at?
It's your brief.
Yes.
I printed.
You're looking at our brief, page tab 11, yes?
Part 8, assessment taxation and other levies on property. We're looking for definition, 315.1.
Okay, I'm just sorry, can you give me a page number specifically that you're referring to in the tab?
You don't have page in your brief.
If you look at the PD, you
I
have the
don't
hard
look
copy.
PDF,
What page on the top left-hand corner would it be on the?
Okay, are we at tab 11, which is the Children's Hospital decision?
Yes, I think that's what she's referring to.
No, tab 14.
Oh, I'm sorry,
14.
tab 14. I'm sorry. Okay, yes, the
Okay.
City of Winnipeg Charter, yes.
First, we're looking for definition of business assessment.
Yes.
Together. Business assessment means the assessment of premise made under Division 1 for purpose of business tax. Let's look for premise definition. Premises means land or building in the city or both, or any part of land of the building occupied or used by person for purpose of carrying on a business. We came back to part 1, 2 pages back. We look for definition on business in our City of Winnipeg Charter Act, part 1, definition in Act. Everyone with me?
I'm not sure I'm with you. Which part of the charter are you reading
We
from?
still on tab 14,
Yes,
City of Winnipeg Charter Act, part 1.
Part one, yes.
It's page 80.
Okay, I'm just making sure I'm with her. Thank you. Go ahead.
Act. Business mean A. Commercial merchandising, industry activities, otherwise. B. Profession, trade, occupancy, calling, or employment. C. Keeping on operating a device or thing. In we look specific on D. An activity providing good or services. So, impact provides service management of parking structure. You can open my rebuttal. I provide extra chain of email with J. Mercury. If you look on page number 5.
Okay.
Okay,
I'm
hold on.
not-
I don't have, can I just bear with me while I obtain that? I haven't seen it yet.
Mr. Chair, I haven't distributed the rebuttal yet. It wasn't mentioned by the assessor. Would you like me to distribute it now?
Yes.
Okay, just a moment, please.
Thanks.
Okay.
Ms. Shable, I think you need to speak into the microphone a little bit clearer, please.
Yes, it's hard to make you
Right,
out at times.
we're having a little bit of a hard time hearing the what sections you're pointing to, so forgive me, but
I will be
speak into the
more
microphone a
loud.
little bit clearer.
Okay. It'll just take me a couple of minutes, Mr. Chair.
Okay.
Okay.
Let us know when you're done.
Yes.
If I just could add, I haven't received a question yet. I appreciate the assessor may wish to present her case, but does she have any specific questions, I suppose, is what I'm
After
looking for.
presentation, I will have questions.
Okay, so I'm just, perhaps if I could ask that if there are any questions on our specific presentation, we deal with those first, and then the assessor can certainly make her case by
Yeah,
taking us through the
yes.
legislation if she likes.
Yeah, Ms. Shable, you will have the opportunity to present on the liability issue, but for
I
now,
don't
we're going to be dealing with specific questions on their argument, as well as the panel will have questions.
Are there any questions, Ms. Shable, that you have?
not yet.
You have questions on his presentation, is what the chairman is asking. Ms.
Yes.
Shable.
First, we'll establish who is owner, who is taxable party. What we're doing right now.
Well,
Yes,
his
that would be.
presentation. Sorry, Mr. Chairman, go ahead.
Yeah, that is part of your presentation. Right now,
It's
it's
not
just.
part of my presentation. My presentation only quantity.
Okay, but we're dealing with liability now,
That's
so.
why open my rebuttal, please.
But I mean, it's your time to ask questions, not present rebuttal, but
Do you have questions, Ms. Shable, of Mr. Mercury or his expert witness, Mr. Cadu?
On your top 11, Children Hospital. This hospital parking was specific for hospital only, correct?
Sorry, 11?
The hospital and its visitors, I don't think there was a restriction on somebody could certainly park there. I wasn't around back in 1963 and don't know precisely how the parkade was used, but if it was the same children's hospital as it is today, I would imagine that the primary users would be visitors of the hospital, but there's no prohibition on where those parkers would go after they park there, if that's your question.
On your top number 12 about Ritz food claim of cafeteria. This for building, municipal building, provincial building. Ritz provide service only inside this building, no public access there, correct?
No, that's not correct, at least to my knowledge. The cafeteria, and certainly I'm well familiar with the Woodsworth building cafeteria, having been there many times. It's open to the public. But there are representatives there. It's in an office building. If you go to the Woodsworth building today, there's still a cafeteria building in the basement, primarily used by employees within the Woodsworth building. But I can tell you, as someone who goes to court fairly regularly, that's where all the lawyers go to eat at lunchtime. It's open to anyone to attend that building and eat in the cafeteria.
And parkade, everyone could park in there, pay parking fee on subject property and go for shopping in same area. They're not specific have to go to hospital, correct?
Are you asking about 790 Sherbrooke?
Correct.
Yes, primarily, I mean, this may be a question for Mr. Cadieux, but the primary users of that parkade would be visitors to the building itself, but they certainly use the parkade for neighboring facilities, including cancer care or even health sciences center. But the primary users of the parkade, I expect, would be visitors of the building. Mr. Cadieux, I don't know if you have anything to add to that in terms of the actual use.
No, you covered it well. Thank you.
Okay, thank you.
On your tab 13, you presented a case from Delta Parking System Limited in Toronto and Township, Toronto. Would you agree that Ontarian law and Manitoba law two different law?
There's certainly different legislation, but the principles are the same. And in fact, Manitoba law often will cite Ontario law in assessment cases. And these business assessments cases, I could go through them in greater detail, but both the Manitoba and the Ontario case are based on a Supreme Court of Canada decision that's referenced in both, actually all three decisions in terms of how we deal with this issue. And the issue is, whose business is it at the end of the day? And there may be many people, many service providers at a building or in a facility, including managers of a parkade. There may be operators who clear snow within a building. There'd be painters within the building. There's, for example, within the office building itself, there's also Mr. Cadieux mentioned C.W. Stevenson. They're the property manager. They're certainly providing a service within that building, but C.W. Stevenson does not receive a business assessment in respect of the premises at 790 Sherbrooke. And that's for good reason. They're providing managerial services for the owner of that building, no different than Impark. And so the principles in Ontario and in Manitoba have been consistent, and they are the same. Whose business is it? And if this were a situation where the premises were leased to a tenant, we would agree that that business assessment should go to the tenant. But this is not a landlord-tenant relationship. So it's very fact specific. And that's why we attempted to engage with the city on this issue. They had asked if Impark was managing the parkade. I indicated that they were, but I also indicated to them that the city that the assessment notices should go to HSCF Property Inc. And for reasons which are not known to me, they decided not to change it. So I can't speak for why the city has decided to issue the assessment as they have.
But you would agree that City of Winnipeg Charter Act defines business specific for subject property and activity providing good or service.
That's a general definition of
provide management for parking stall.
Yeah, there's a definition of business in the City of Winnipeg Charter. You have to remember the City of Winnipeg Charter has, I think, over 400 sections in it with various different provisions dealing with businesses in the city. Business tax is one part of it. When you get to business assessment and business tax, you have to look more carefully at the actual definitions of the business assessment, and you have to read those legislative definitions in the context of the case law that has developed over the years. And I provided 3 cases which are directly on point. Because if you took it literally, if you read it literally, as the points was made in the Ritz Food case, that you'd have potentially endless number of business assessments going to the same premises. As I mentioned, to the painter, to the cleaner, to the manager, to you name it, anybody who's to the electrician who's providing services at that building. They all have their own business and they are operating for a profit, but it's not their business. If it's a cafeteria or a parkade or some other service that's being provided, you have to ask yourself whose business is it? Is it a daycare service, for example? And in this instance, and that's why we provided the memo of Mr. Cadieux, this is the owner's business. This is their operation, not Impark. And there can only be one assessed party.
So everyone has my rebuttal?
Let's see, do we have it, Crystal?
Yes, it should be in your OneDrive file, Mr. Chair.
Okay,
And I've sent it to Mr. Mercury.
We open page 4 PDF file. My colleague contact Jamie Mercury on November
okay,
21.
is this rebuttal?
Yes, it's
Yeah.
part of rebuttal.
Okay, well then we will deal with
It's
rebuttal
part of
after.
rebuttal to classification only.
Yeah, well, we'll deal with
It's
that
not part
after.
in info. Please.
Excuse me, Ms. Scheibel, I am speaking here. We'll deal with your rebuttal after the board has asked questions of the
But
Mr.
sorry.
Mercury. Then you can present your rebuttal after that.
It's rebuttal. It's email conversation. We try to discover what taxable party is.
Yeah, well, Mr.
Before
Chair, I don't
create
mind.
new
Yeah.
roll number.
So,
It's 1 minute to look, everyone.
Mr. Chair, I don't have an issue with dealing with the document that Ms. Scheibel is referring to, and I can clarify it very easily. She's referring to it's a 5-page PDF. She's drawing to the board's attention an email that I had with Mr. Tyler Kloak of the city of Winnipeg, dated November 21, 2024, and she's asking me to look at that in terms of the reference to the Impark managing the parking lot premises of HSCF Property Inc. So the question, I don't know the purpose of the question. The context of the email was we were trying to correct the issue of a bailiff attempting to issue seizure notices against either Impark or HSCF Property Inc. improperly. And they started to ask questions about who's managing the parkade, and I responded, Impark is managing the parking lot. And it was separate from the issue I was attempting to address at the time, was the old business tax bill being issued and seizure notices being issued by the city of Winnipeg improperly. So I'm not sure what the purpose of the rebuttal document is. But I've never
Okay, we'll let Ms. Scheibel ask her questions on this document first of all. So
do you
go
have a
ahead.
question, Ms. Scheibel?
Yes, on this document, my colleague asked, we were informed yearly regarding 311 case.
Yes.
On page number 5, this year that HSFCF Property Inc. would be operating the paid parking lot in the Manitoba cleaning. But I have just done a quick search. It looks like Impact in handling this. Can you please confirm that Impact is a business handling this, and I can proceed with switch to produce new roll number? On page 4, J. Mercury respond, I'm informed that Impact is managing the parking lot premise for HSCF Property Inc. So we cancel a previous number, business number 26427, issue it to HSSF Property Inc. to create new roll number today under appeal 58129 for Imperial Parking Limited. It's what
Yes.
part of my rebuttal. That's it.
I see that. However, at no point in time did I ever ask the city to switch the assessment to Impark. I simply responded indicating that Impark is managing the parkade, nor do I, as an agent for the owner, have authority to direct the city of Winnipeg as to how to issue its business assessments. Impark and HSCF Property Inc. are totally unrelated third parties, unrelated parties. They don't have common ownership. They're totally separate. The city decided to change the business assessment. I asked them to not do that. Ultimately, I asked them to change it back because I took the position that was wrong. But at no point in time have I ever indicated, nor do I have the authority to indicate that the city issue business assessments in the name of Impark. So I don't understand why the city would even ask me that question. I am not the person to ask that question. They should be going to their supervisor and seeking that authority, not me.
The city clean following the City of Winnipeg Charter Act and definition business. Business on D, 1D, it's activity providing good and service. Everyone knows that Impact provide managing parking structure and parking lot across the city. It's business for profit.
Okay, is there a question that you have?
No.
Okay, we're on questions here. Do you have any more questions of
No
Mr.
question.
Okay, Mr. Colatrigio, any questions of Mr. Mercury? Or
All right, Mr. Mercury, I'm looking at this as you have an assessment against Impark. You have made it fairly clear that that assessment, in your opinion, should be made against HSC Foundation, correct?
That's correct.
And the reason for that, in your opinion, the case law that you quoted, which is, as you said, right on point. Has there been any further case law on this, or has this been decided long ago and still stands today?
Yeah, my understanding, and it's a good question because I did look into this. My understanding is this is fairly settled law. The case I mentioned to you, 1963, the Children's Hospital case came forward, which I think is pretty much as on point as you can get, although the only difference there, we had a hospital, not a HS. This is essentially the old Manitoba Clinic building. It's has medical services being provided. It's not a hospital. The Ritz Foods case in 1982, I believe, would have thought clarified the law. It's funny because you ask, because when I was at the Board of Revision, I think it was about 15 years ago, when it was still on Assiniboine Avenue back in the day, I distinctly recall arguing this case for the Compass Group and the same case law, and I brought Ritz Foods case in 1982 case to the Board of Revision, and one of the board members asked me and made a comment, well, this is an old case, and another board member turned to her and stated, well, just because it's old doesn't mean it's out of date. And I think the same logic is would apply today in 2025. I haven't been able to find anything more current, certainly not in Manitoba. I'm 99.9% certain that there's no more recent case law in Manitoba that would have changed this law as good law. And the ultimate question is, whose business is it? And you do have to look into it. Is there a lease? Who has control? And it's a case by case.
Is in fact the test that I recall.
Absolutely.
For business tax in Winnipeg.
Correct.
If you have both of those things, in essence, you are the person. You are the entity at that point.
That's right.
That's what you're trying to demonstrate here, correct?
That's correct. It's carrying control, and if you look at that's further elaborated on in the case law. So you ask yourself, like, who sets the parking rates? Who has control over expenditures? Who sets the hours?
That's not a tenant owner agreement.
No.
It
If
is
you
a
have a
management
lease,
agreement.
right, if you have a lease, the tenant typically has the right to quiet enjoyment and can run their business as they see fit within certain
Correct.
parameters. But it's their business, they profit, and it's none of the landlord's business at the end of the day how much they profit and how they run their business, so long as they're complying with the bylaws and the rules of the building, so to speak. But here, that's not what we have. It's not a case where the owner turns the keys over to the parkade to a parking operator and says, go do your thing and give us a cut at the end of the day. It's quite the reverse, in fact. So it's the
Right.
HSCF runs the parkade. They give a percentage to the parking manager, and the parking manager doesn't get a business assessment because of that. No different than someone came to paint the building. Uh, wouldn't be assessed. They're profiting off their painting business, but are they liable for business assessment? Same as Colliers or Stevenson or any other management company manages buildings across in the city of Winnipeg. They certainly provide a service in the building, and they often operate on a percentage basis, but they don't get assessed for business tax purposes.
Okay.
So in my view, the case law is clear on this, and it's unfortunate that we've had to come to this trouble to deal with it. I thought it was settled law myself, but here we are.
There seems to be, at one point, the business assessment was actually put in HSC Foundation's name, but then it got changed yet again to the Embark people.
That's correct. And what I find most interesting is that even prior to HSCF coming on the scene, the prior business assessment notices for the parkade were issued in the Manitoba Clinic Holding Co. Ltd., not Impark. Impark was managing, as you heard from Mr. Keddu, has been managing this parkade since I believe 2017, if I'm not mistaken. And
19 that I'm aware of.
20 was it 2019? 19.
July
Okay, I'm
19.
sorry.
Yeah.
19. Thank you. 2019, but you saw the assessment notices at least going back to 2022. As of that time, assessment notices were going to the prior owner. There were unpaid business tax bills. Clearly, they had been issuing not only assessment notices, but business tax bills to the prior owner who couldn't pay its bills. And you saw the result of that. So, it's unfortunate that they just made the decision to switch it. I got ahead of it because I was told verbally that this was going to be happening. I tried to proactively reach out to the taxation department to kind of plead my case, so to speak, to say this is not Impark's business. But they determined that this was appropriate and they were going to proceed. So I certainly didn't authorize it. In fact, quite the contrary, I asked them not to do this. And you've seen the supplementals that have been issued.
And that's why we're here today.
That's why we're here today.
I think I'm gonna reserve the rest of my questions for Ms. Shable at this point, but thank you for your presentation, Mr. Mercury.
Thank you.
Okay, Ms. Werhun, any questions?
No, mine have all been answered. Thank you.
Okay, in terms of your quote there, it being old but not necessarily out of date law, my, I guess, concerns with those older decisions is that the law has changed since then. I mean, obviously Children's Hospital predated the City of Winnipeg Charter by a considerable length of time. So are those still, in your opinion, applicable to the current law?
Yeah, it's a good question, but the answer to that is absolutely they are still applicable, and in particular the Ritz Foods case, which is a relatively more recent decision than the Children's Hospital case that did deal with the City of Winnipeg Charter and the fundamental principles of assessment law in Manitoba, or in the City of Winnipeg, I should say, for business assessment. And you can see they reference the old City of Winnipeg Act 1971. I'm looking at page 67. Every person carrying on a business in the city, whether he resides therein or not, shall be assessed for a sum equal to the annual rental value of the premises which he occupies and carrying on or uses for the purposes of such business or uses in any way except using solely for residential purposes. And that's the business assessment. And if you look at the definition of today in the City of Winnipeg Charter, it's almost identical. Section 316. Premises used, occupied by a person carrying on business in the city, whether it resides in the city, must be assessed for business assessment at a sum equal to their annual rental value of the premises. And so the principal in Ritz Foods, which is the Manitoba Court of Appeal, that's the highest court we have in Manitoba, that has not been revisited, has not been changed. The legislation has not been materially changed since that time. And they say that at the end of the day, who is in care and control of these premises, as Mr. Colatruglu indicated, that's the test. And if you're just managing, if you're just being put in charge of a business, that's not sufficient for business assessment purposes. I would note that under the City of Winnipeg Charter, and we did include this at the very end of the brief, if the city in its wisdom wishes to pass a bylaw to requiring a license in lieu of essentially in lieu of business tax on the premises, they can do that under Section 320. And so you can see Section 320 sub 1, if a person occupies a premise or class of premises for which an assessor finds it impractical to determine annual rental value, to have a license in lieu of business tax, or who does not occupy the premises for the purpose of carrying on a business, to have a license in lieu of business tax. So there's other things if the city in its wisdom wants to collect, whether it be a license fee or other revenue from operators of a business, whether it be a manager of a parkade or some other operator, there's mechanisms to do it. But when we're talking about annual rental value of premises, specific premises, the question really is summarizing who's got care and control of that quote unquote business and who has paramount care and control. That's the party to assess. And so in the cases when we're dealing with this in the terms of exempt entities, this is where it's particularly important, right? We have hospitals, we may have schools, universities, and they decide to have, rather than have a university employee, for example, run a food services cafeteria or manage their parkade, they just hire an independent contractor to come in and manage or provide the service. That's just an operational decision that the owner makes, but it does not give rise to a separate business assessment, absent any other factors such as entering into a lease or essentially giving complete care and control over that specific business unit to the third party. So the law, to answer your question, the law has not changed, at least not to my knowledge. This is it's certainly the law in Manitoba. It's been the law in Ontario. It's the law in other provinces as well. I decided not to flood the Board of Revision here with case law from across the the country, but I've satisfied myself that this remains good law in Manitoba.
Okay. Last question was, did you do any search on these decisions to determine if they were referenced in any later decisions?
Yes. Certainly, I have them noted up in front of me? Yes. Well, sorry, I don't have them in front of me. I could quickly do that. But Ritz Foods, I'm just looking at that right now. It was actually cited with authority in 1998 by the Ontario Court of Appeal in a case called Guittardo Properties. It's been approved by the highest court in Ontario. So other provinces have dealt with this issue as well, and when their business assessment issued, for example, in businesses within an airport, I've seen that, or at hospitals or schools, for example. This case, at least in one other case, the Ritz Foods decision has been cited with approval about 15 years later.
Okay. Thank you very much. I have no more questions. Ms. Shable, then your presentation on liability.
It's up to agent to defend liability.
All right,
Well, the agent has the
burden of proof.
burden of proof,
Burden of
but
proof, yes.
once they make a prima facie case, then the city, the burden switches to the city.
I already point that city following the City of Winnipeg Charter Act says 2002, and subject property, its impact, its business. In this definition showed the activity provide good and service, so impact provide management of parking stall, and this impact across the city provide management of parking stall and parking lot. It's working for profit. It's under assessment of business tax.
Okay. Any
And
question?
when we ask who is taxable party for parking structure, we receive answers that it's managed by impact in November 21st, 2024, when we create new business role specific for impact. What today under appeal, number 58129.
Okay. Any questions, Mr. Mercury?
Yes, Mr. Shable, you do acknowledge that I asked the city taxation department not to issue the assessments, the supplemental assessments in the name of Impark. Are you aware of that?
I provide evidence, our correspondent email, it was clear, state impact, what we create new roll number regarding 311 inquiry.
So that wasn't my question. My question was, you are aware that I had specifically asked recently, within the last month and a half, not for these supplementals not to be issued in the name of in the name of Impark, and the response was that the supervisor had indicated that's what they were going to do. You're aware of that?
Yes, it's management decision, yes, because
Okay.
we following the City of Winnipeg Charter Act.
All right. And are you able to explain then why it is that prior business assessments for the parkade were issued in the name of the owner of the building and not Impark?
We have issued an owner name, but you specific request to change this name.
Ms.
In
Scheibel,
November
that you know
20
that's incorrect, so you keep stating that I specifically advised the city of Winnipeg to change it to Impark. You are aware that that is incorrect, so I would ask that you please not make those incorrect statements.
If you open page number 3, previous roll tab number 3 in your brief, previous roll number was 26427, issued at ASCF Property Inc.
Yes?
And city issued total debt or 43,000.
That's a prior debt to Manitoba Clinic Holding Co. Ltd.
We changed name to owner, current owner. But
All right, I'm not going to ask any further questions because assessor's not answering the questions, and I don't really see this as relevant. But those are my questions, Mr. Chairman. Thank you.
Okay, Ms. Werhan, any questions of the city?
Not right now, thank you.
Okay, Mr. Colatriglio.
Thank you very much, Mr. Chairman. Ms. Shable, you've obviously seen what Mr. Mercury has sent back and forth. Do you understand the difference between a tenant and just a management company?
yes.
Okay. And who ultimately made the decision to change this to the management company for business assessment in this instance? Was that you or was that your direct supervisor?
If you look my rebuttal, On page number 5 of PDF file, we specific ask owner through J. Mercury, who we were informed current this year that HSCF Property Inc. would be operate the paid parking lot at the Manitoba Clinic. But I have just done a quick search. It look like Impact is holding this. Can you please confirm that Impact in the business holding this? And I can proceed the switch. Switch, it means a new roll number. If we receive clear response on November 21st, 2024 at 2:31 p.m. Taylor, yes, I am informed that Impact in managing the parking lot premise for HSCF Property Inc.
Hey, Ms. Shable,
So
I
we
understand what
create
you're
new roll
saying.
number.
Forgive me, but I'm trying to understand who ultimately made the decision to change it from HSC CF Property Inc. to Impark. Was that Tyler Kowalik? Or was that you?
It's-
Or was that your supervisor?
Because we receive response for all.
No, I'm asking a very specific question. Please answer it. Do you know who made that decision, Miss Shable?
Our management.
Your management.
Yes,
Who exactly? Your area coordinator?
correct.
Your area coordinator made this decision. Did he have any contact with the city of Winnipeg Law Department to ask if this was a reasonable position to take after Mr. Mercury has given you the information on a silver platter? Do you know if that was done, Ms. Shable? You don't, do you?
We changed role in
You know it from that
2024
law.
after contact the owner.
Ms. Shable,
Information provided
you're
by.
not answering my question, Ms. Shable, and I want you to answer it, please. I'm asking now for the second time, did your supervisor, your area coordinator, ask the law department whether this is proper to do or not?
Yes,
You
Because
certain of that?
it's by City of Winnipeg Charter Act.
The act is one thing, but if you're interpreting it as this management company, not a tenant, they don't have full care and control of this property. That does not meet the definition as far as I understand it. So please, did this get pushed up to law department or not? And if you don't know, that's fine, I get it. You don't know, do you? Thank you. You've answered my question. And those are my questions. Thank you very much.
Okay, and I have no questions that haven't been asked and answered. So I guess we deal with value next.
It's up to the board how you'd like to decide this. What I'm trying to avoid is having, I know Mr. Neufeld is here. What I can say on the issue of value, without getting into it, is that we already had a realty appeal. I can't recall if any members, perhaps Mr. Colatruglio was on that panel. Not sure, can't recall.
It's the same panel.
It's the same panel. Okay, so the panel would have dealt with parking income at the time, and a determination was made on value. That makes it even easier, Mr. Chairman. But you can deal with it if you like. There were 559 stalls that have been assessed here, and you can see that from the assessor's brief. All that we have done in the assessor, and Mr. Neufeld can walk you through that briefly if you like. As I said, it's moot if depending on what you decide on the liability issue, because there would have to be supplemental assessments issued, and we'd be dealing with it then. But if you'd like to deal with it now, we can. My suggestion, and I just put this out for your consideration, is that if you want to briefly adjourn amongst yourselves to determine the liability issue, that would frankly end the appeal. because the city would then have an opportunity to issue supplementals in the correct name, and we would deal with value. But I'm happy to deal with value now, because if we deal with it now, then presumably the next panel would respect that determination. But I'll leave it up to you.
Yeah, that's, I guess, somewhat of an unusual way of proceeding, but I do see the merit in it. Perhaps we can take a brief adjournment and the panel will consider whether to issue a decision now or to proceed with the valuation.
Okay, very well.
All right, thank you. Welcome back. The board has conferred, and we will proceed to hear value. So, Ms. Scheibel, you have the onus on value, so your presentation, please.
Thank you. File number 25-131, business roll number 58129. We did assess 2024 total annual rental value at 613,440 for total number of stall 559 stall. It's a parking structure unheated. Monthly net units rent dollar per stall we assess at $92. On page number 1, I presented 2020 reported rental rate for surface parking. Structure parking, it's not correct. So my first comparables of 374 Taché Avenue has 466 unheated stalls, give us established net operating income per stall per month, $109.31, and we assess $92 per comparable number 299 4th Street has heated 929 stalls, net stabilized net operating income $120.15. Comparable number 3, 136 McDermott Avenue has 270 stalls both, and stabilized net operating income per stall per month $114.46. Comparable number 4, 230 James Avenue, 59 heated stall, net operating income per stall per month $135.89. Comparable number 5, 170 McDermott Avenue has 265 unheated stalls, and stabilized net operating income per stall per month $130.23. Comparable number 6 on Lombard Avenue has both heated and unheated, 677 stalls, $98.32. That gives us mean average $180.06 and media $117.31. My 6 comparables showed that our assessment and stabilized net operating income per stall per month $92 is reasonable. On page number 2, air photos of parking structure and office building on top, and photo of my comparables. On comparable number 3, 374 Taché parking stall, 100 King parking stall. On page number 4, 299 4th Street and Lombard. On page number 5, I present information about full property. We have medical office with parking structure and parking lot. We assess 18 stalls exempt because they are occupied by share health.
Can I interrupt you here, Ms. Scheibel?
Yes, please.
The previous panel made the decision on liability.
Yeah,
Why was this not carried forward?
it's carry forward. I just showed how we came across 559 stalls from
But
existing 639 stalls. On page
but
number
we
6,
the previous panel did not agree with 80 stalls. They definitely increased the exempt portion to 54%, I believe it was.
this 30% was exemption for share health occupied space in office building in 80 stalls separate.
All right.
On page
Continue.
number okay. On page number 6 and 7, I showed how much share health pay for their parking, $132 per month. In our estimated net operating income, $92 per month. On page number 8, we're looking for actual rate as April 1st, 2021. It's Manitoba cleaning lot number 56 during assessment. And we can see hourly $14 per square foot, daily $15, and evening rate $375. On page number 9, I was searching for impact, who is business owner. We can see that Impact, it's North American Parking Management Company, as of 2020, is one of the largest parking management company in North America, operated approximately 3,400 parking facility with 9,000 employees in more than 240 cities across United States and Canada. And it's following by appeal in our assessment. So based on my evidence, I ask to confirm the 2024 total annual value of $613,440. Thank you. Any questions?
Questions, Mr. Mercury or Mr. Neufeld?
I'll turn it over to Mr. Neufeld at least to begin on this.
Yes, thank you. And I had that great intro from Mr. Mercury earlier about sometimes if it's older, it still stands. This we're talking with about, I just want to clear, this is file 25131.
It's the 2024 assessment
Okay.
here.
Okay, and just I'm looking, I believe that they're identical. So I don't see a need for us to argue the second one unless everybody wants to. I'm just going to point that out. Okay, so my questions. First of all, on the annual net rent, it shows 617,136, yet the rental value is 613,440. Why was this adjusted?
It's total annual rental value by business 58129 for 559 stalls at net operating income $92 per stall.
I'm sorry, I'm used to seeing the annual net rent equaling the annual rental value after costs have been added to it. And in this case, it was decreased. Why was it decreased?
After because we don't for parking stall, it's already net stabilized net operating income per stall per month. So we don't include any occupancy cost.
And how many parking areas are on the city's assessment rolls on this property?
I don't have answer.
Well, on your page 5, you have 2 listed, correct?
I showed that parking structure together has 639 stalls. We took out 80 stalls occupied by Share Health. So under assessment, 559 stalls.
Okay, I've just question was simple. You have provided two here, but there's a third lot, is there not, that has 13 stalls on it that you have
It's
not
not
shown the
under
board?
assessment today, not under business assessment.
That's not the question. Is there a third lot that the city has on their tax rolls? And I refer to the realty tax roll. You presented that, correct? There's
We
three lots.
have outdoor parking on page number 5. We have outdoor parking 13 lots. 13 lots.
Okay, so you don't know where that third roll is, or does it exist?
It's not business assessment.
And this particular business assessment, can you tell me where the location of it is in the building?
It's parking structure.
Correct, but there's two parking structures in the building. Do you know which one it is?
It's only one parking structure in the building.
They're not, you don't, have you been to the building?
We have indoor parking structure, 639 stalls. 18 stalls occupied, it's exempt, but under assessment for 559 stalls.
Okay, so you're not aware that there's a second section then, another section, are you?
It's not part of assessment.
And the comparables that you've put in here, are these the same ones that were presented for the realty appeal?
I'm not sure.
Okay, well, I don't want to spend a lot of time
I
on.
did select it. I just look for 2020 reported rental rate because I defend 2024. To defend 2025, I look for parking structure report from 2022 reported to us.
Are any of these your comparables on hospital land?
My comparables, it's parking structure, heated, not heated, or both. What we
Are
look
any of
for.
them on hospital lands?
It's close to the subject property,
Yes or no?
downtown.
Okay. Did you note that as the stall count increases, that your expense ratio increases?
It's what reported to us, yes?
Did you note that it increases with size? For example, 926.
Biggest number 2 to 299 Ford, expense ratio 51, so provided to us, and 677 stall, much lower, 59%. So it's not true.
In your analysis of this, was there any thought given to trying to establish a graph or a ratio of the expense ratio versus the stall count?
We provide expense ratio clearly around 44% and media 42% from 6 comparables.
In the Board of Revision decision on the realty, they confirmed the value of the parking revenue at 626,417 for all three lots. Just wondering why that didn't flow through to the business.
Because business under separate appeal.
I believe you've been through many cases where the business flowed through automatically, administratively, from a decision of the board at realty to business. Why wasn't it done in this case?
In my case, a set of comparables shows that our assessment and stabilized net operating income per stall per month, $92 per stall, it's fair, much lower than what my comparable.
Okay, well, for example, in Fawcett Auto Body, where you made a mistake on the size of the building, your supervisor immediately changed both the realty role and floated through automatically to business without an appeal. Isn't that something you just do to follow up on the first decision?
I cannot comment that I am not part of.
Those are my questions.
Okay, Mr. Colatriglio, questions?
No, I don't have any questions. Thank you very much.
Ms. Werhun?
None, thank you.
Um, okay, I have no questions. So, Mr. Neufeld, you can give your presentation.
Thank you. I think it's in Mr. Mercury Book of Documents, tab something, tab 1.
It's tab 1. There's a replacement page that I had sent to the board. There was just Mr. Neufeld had one page that had the incorrect chart.
Yeah, actually, the assessor has cleared that up for us and supplied the
Okay.
missing amount, which is fortunate, so we don't have to change any, worry about introducing evidence late.
Okay.
What on tab 1, page 1 is just our workup on it. At the top, you'll see that there are 3 lots, and we've just listed the number of stalls. And from the city rent where it's listed, that comes from the realty roll. And you'll notice the 617,136 from the realty roll. And I was questioning why the annual rental value went to 613,440. I don't suppose it's a big issue, but I was just curious. What we did from this is that the 626,417, which the board applied, was just prorated and allocated to the subject, indicating a value of 537,066 for annual rental value. So this is just a pure flow through. Both years have the same numbers, both in realty and in business. Page 1 is the assessment for the subject property for business. On page 2, this is a mistaken page, my error here. However, the city did put in the right roll. So ignore that page and look at the city's page 5 for income stream 5. It's listed at the bottom of the page. That's the one that was supposed to go in there. That's the 80 stalls. Actually, I couldn't find that premise ID. But it was plugged in with another one on there. So that's we'll call that one number 2, and then number 3. Okay, sorry, I did have it in. Oh no, that was my replacement page. Number 3 was not assessed at all. Now on page 3 of it, this is clipped from the city evidence at the realty presentation. These are the income streams, and it's income streams 4, 5, and 1. So this shows in the realty rolls what they had on their records. And 559 stalls in number 1 are subject, 80 in the tenant space. The city's presented that. And income stream 1 is the exterior parking, and it's 13 stalls of exterior parking. So this was presented to the board, and this is the assessor's position at the time, what the value was of that parking revenue. And on page 4 was our position, where we had the 626,417. This is clipped from both of our presentations to the board. And on page 5 are summary reports that the board decided, and I guess you were all there. So you said decision is based on net operating income presented by the applicant, and you changed the cap rate. And that's how we came up with 627,417. Also, and I don't know where you're going with the liability issue, but we have put the ratios in as well. The 53.6% was what you agreed on the class class 40 exempt. Or is it the other way around? Oh, I think you got it backwards. Oh, well, what do I know?
The exempt portion was 53.6, I believe.
Yeah, but now I'm looking at the order and you have different ratios in there. It looks like you may have reversed them. I never caught that. You know, on my page 5, see the 40, the exempt was, oh, no, sorry, no. I read that wrong. The board got it right. Sorry. I was
Of
looking
course
at the
we
first,
did.
I was looking at the first columns and not your conclusion columns. So those are your ratios there. Page 6, those are pictures I took on my inspection. There's a little heated structure to go up and down. And there are separate parking areas. One is sort of a general open and scramble. The other is blocked off for the monthly parkers under contract. And then the one up front on my page 7, this is the missing income stream that the city didn't present this time around. You see at the north of the building, there are 13 stalls there, and most of them are marked for barrier-free access. I see one that isn't. I believe it's all barrier-free access, but that was part of the income stream that we had both presented. 3 parking lots with a total of 652 stalls. And the ratio there becomes 85.74% of 626,417. The only other recap on there, since I'm trusting you had wonderful memories, is that this is different than a normal parking lot. It's 24/7, so the cost to operate are higher. And that was the point that we made at our first hearing, why the expense ratios are higher than other lots around pay lots around the city. There's an added responsibility with hospital. They've got their own security going around 24/7. So it's just more expensive to operate a hospital parking lot, and therefore I think that's a big part of it, is that the expense ratios are higher. That's what we're asking for. That's it.
Okay, what specific value are asking for the parking lot for 2014?
537,066. And I have no idea where you're going in the liability. I'm sure you have those numbers in your head.
That's the 60T portion you.
No. I mean, like as it stands today, I didn't catch a lot of what you were discussing on liability and exemption. But if you were simply doing a flow through on the first order, then the breakdown should be, I'm in somebody else's office and I don't have a calculator here. It would be 537,066 times 53.6% being
exempt.
Exempt, correct. And that's that again, I'm just flowing through with the order. I'm not I know that there's a larger issue at stake, but
So that would be 287,867.
287,867. That looks pretty close, yes.
So that's 40T or 40E.
40E.
And the rest would be 60T.
Correct. Well, as a flow through, yeah.
Yeah.
And Mr. Mercury is going to jump in here and
deal with it. Yeah, I think we might be confusing carrying over realty issues into the business assessment. 80 stalls have already been excluded as they're not even assessed within the shared health space. But
yes, you're right.
As Ms. Scheibel correctly pointed out, but I think there is a legitimate issue in the sense that the board did determine that I think it was 53 I don't know, is it 53.6%
Yes.
of the overall value of the property, including the parkade, was subject to an
Exemption.
an exemption. So based on the use by the exempt entity. So the complicating factor is now you have to look at the overall rental value of the property and apply that ratio. And I don't have the annual rental value in front of us with respect to the building portions. So that is a bit of a complicated exercise, if you're following me, to carry it over. I think at this juncture, what we're wanting to do is just simply, fortunately, on the liability side, our position is that because it's issued in the name of the incorrect party, it's not subject to, it's not liable to business tax in Park, because that's how it's been assessed currently. I don't think we need to get into, if it was assessed in the name of HSCF Property Inc., I think we perhaps could get into these issues, but that would be a bit of a hypothetical at this point in time. I think on value, we're just looking at the, what is the value of the lot? And if you look at page 4 of the PDF, as Mr. Neufeld correctly indicated, he just simply took the parking income that the board accepted at the realty and then prorated it to the 559 stalls. So, or 85.74% of the parkade to arrive at 537,066.
Okay. But okay, I understand. Perhaps I'll ask this of the assessor too. Do you know if either the value or liability was appealed on this property?
Sorry, both liability and value has been appealed on the parking lot, the parkade. That's the only assessment before you.
I think he's asking further at the realty at municipal board.
Oh, I'm sorry. The liability has not been challenged at the court. Value.
We don't know.
Okay.
Because
Yeah.
the board is months behind. I'm getting notices from appeals filed in January and February right now. So who knows? But he asked the assessor the question.
Yeah, the assessor might be able to answer that question. We don't know.
Okay, thank you. Okay, Ms. Scheibel, do you have questions of Mr. Neufeld?
Yes, please open page number 4. We looking for parking rent. You asking 626,417, correct?
That's correct.
So you did apply ratio on page number 185.74% to came across 557.66, correct?
That's correct.
Okay. You for 2024, your around realty assessment was 33,537,000. Board decide for 2024 on page number 5, 37,130,000. Did account for this change if in board of decision much higher than you requested?
I'm sorry, what was the question?
So my question, you did requested 33.5 million. Board decide 37.13 million. So
Yeah,
it's
well,
much higher.
No,
So
it's not. That's not the case. The board made a decision. I'm answering your question. Read the decision. It says the board accepted the income provided by the applicant and changed the cap rate. That is not part of annual rental value. That's the cap rate. That's real estate value. So they accepted the income stream.
But by the end of the day, it's instead of 33 million, board decide 37 million. It would be affect parking net in your new estimation decision by.
No, you're misleading the board. That's an improper question.
No further question.
Okay, Ms. Werhan, any questions?
None, thank you.
Mr. Colatriglio?
No questions, thank you.
All right, so kind of asked my questions and we went along here, so I've got no more additional questions, but I wasn't taken to task. All right, I think that concludes 2024. So we'll go on to 2025. So Ms. Scheibel, can you give us the base information for 2025?
Thank you. File number 25-132, business roll number 58123, owner Imperial Parking Limited. We did assess 2025 559 stall at stabilized net operating income per stall per month $92 per stall. It gives us total annual rental value of $613,440. On page number 1, I presented 2022 reported rental rate for.
Okay, we have to deal with liability first, so we'll deal with liability without either party feeling the need to repeat what was said in 2000 for the 2024 year. Is there anything you wish to add, Mr. Mercury?
No, the presentation is the exact same as 24, so I would just repeat and rely upon the earlier presentation, Mr. Chairman.
Okay, Ms. Scheibel, anything new to add for 2025?
Yes, our reported rent comparables number 2 for 374 per share.
Okay, but we're not dealing with value right now. We're dealing with liability.
It's under full taxable.
Okay. All right, so on value then, Ms. Scheibel.
I present 4 comparables. My first comparables 374 Tash Avenue. It's stabilized net operating income per stall per month, $132.52. If you can see in 2020, it was only $109.31. So stabilized net operating income in 2 years going up. 299 4th Street. We have 780 stalls for $128.99. Third comparables 100 King Street, unheated 157 stalls for $103.22. Incomparable on Lombard 677 stalls at $92.90. Based on page 2, same photo, subject property, photo of my comparables, it's same. You can look on page number 8. Now we have same parking, Manitoba Cleaning Lot 56 in 2022. They took hourly $4 per hour or $5.25. 2 hours $10, $15 per hour, daily $15 all day, evening $4. And we assess $92 stabilized net operating income with stall per month. Based of my evidence, asked to confirm the 2025 total annual rental value of $630,440. Thank you.
All right, any questions, Mr. Neufeld, that haven't been asked before?
Just one. Same question, though. Same question, different evidence to review. Does not your evidence show that the higher the stall count goes, the higher your expense ratio is?
You can see that average in 2022, $53 per square foot. It's a ratio much higher compared to 2020.
Number 2 and number 4 have more stalls and they're 60% plus expense ratios. Number 1 and 3 are less stalls and they're in the 40s. Does that not mean that indicate your evidence that the more stalls you have, the higher your expense ratio is?
It's not so clear. My 4 comparables showed stabilized net operating income per stall average $114.23. We assess at $92. It's fair. It's much lower.
No other questions.
Okay, any questions, Mr. Colatriglio?
Yes, Ms. Shavel, further to the question Mr. Neufeld just asked, just quickly. It appears that he's talking about expense ratios on the comparisons that you have on page 1 of your brief. Is it not true that the index numbers 2 and 4 are both, or 2 and 3? Or sorry, 2 and 4, sorry, are both have heated components to them, and that would account for the additional expense in both of those locations, as opposed to unheated like the subject and the other 2 indexes, 1 and 3. Would that be correct?
You're right. This expense are much higher because they have heated and unheated together. That's why expense ratio much higher. Good point. Thank you.
Those are my questions. Thank you.
Okay, Ms. Werhan, questions?
Along that same line, on her last presentation, her comparable 299 Fourth Street had 926 stalls. And in this, her second comparable report, it only has 780 stalls. What's?
That why it is showed a poster. They supported evidence for 780 stalls.
Is there a change there?
Yeah, like, I'm sorry, where's the difference?
And count of stall.
But why such a big difference?
Because it was reported for us that these 780 stall have an expense ratio 65%, and now stabilized net operating income per stall much higher, $128.99.
Ms. Shavel,
I just showed what reported to us. It's reported by the owner.
appreciate that. But I see that there's an asterisk beside
Yeah.
780 stall count, correct?
Yes, different.
Is it possible that that might be something to do with the brand new residential tower that's been put up there?
Yes, it's true. It's yes.
Is that maybe accounting for the difference?
Yes, sorry to
Could be
interrupt,
accounted
but
for.
I'm not sure if that is fair to ask. It's introducing of evidence. Never heard anything about this. It's not in the report. And
Well, that's my question. Is it possible that that's the
I don't know
difference?
anything.
Yeah.
I mean, I don't know anything about a new residential tower. It's not in the evidence.
My evidence 780 stall. Estimated net operating income $128.99.
Yeah, I would think, Mr. Colatriglio, that's kind of speculative anyhow.
I was just speculating, Mr. Chairman.
Yeah, yeah. Okay, Ms. Werhan, any questions of the assessor?
Well, I didn't understand where the difference was, and I understand that some are reported and some aren't, but I'll just leave it at that for now. Thank you.
Okay, and Ms. Scheibel, has the realty decision been appealed, either for liability or for value?
Not appealed.
Okay. Thank you. So Mr. Neufeld, your presentation, and again, you don't need to repeat if there's anything else you'd like to add for 25.
Absolutely nothing else. I have 15-second summation.
Okay, well, this is the first. Let's note this down that Rocky was given the chance to speak and didn't.
50 seconds.
I'll make it, yeah, okay, well, hopefully I have something to amuse you in my summation.
Okay, summation, Ms. Scheibel.
Our assessment for 559 stall at $92 stabilized net operating income per stall per month, very well supported by my comparables and market rent. I ask him to confirm the 2025 total annual rental value at $630,440. Thank you.
Okay, Mr. Neufeld, we've been waiting with bated breath for this, so go ahead.
Well, I'm in Calgary now on a job, and I'm in the office at Colliers, and I was looking out my window, and there's this parkade structure, and there's some surface parking. And that's just a really good example of if you got surface parking, you're not spending a nickel on it because it's got a different highest and best use. That's for future development. If you got a parkade, you got to put your money into it, spend on it. That's why the expense ratios differ. And again, it's not a major point. The bottom line is there was a decision, neither party appealed it. It should have flown through. Our number is 500 and something thousand, which flows perfectly. 537,000 flows perfectly with the order. And as far as anything to do with liability, that's turn over to Mr. Mercury.
Yeah, Mr. Mercury, we don't need to repeat what we've already heard.
No, I have no further comments, Mr. Chairman. Thank you.
All right, thank you. So we've now heard all items on today's agenda, and this hearing is now adjourned. Thank you very much.
Thank you.
Thank you. Have a great day.
Thank you. And the panel will confer.
Right, Mr. Chair, I will get us offline.
Okay.
With these.
And I will say that Canadian Blood Services has an uncanny ability to phone me when I'm in a hearing.